The Pietermaritzburg High Court has declared long-term land leases the Ingonyama Trust has entered into with occupants of traditional land in KwaZulu-Natal unlawful and invalid. 7 people, together with a number of NGOs, took the Ingonyama Trust Board to court after those given permission to occupy land were forced to sign leases. The Minister of Rural Development and Land Reform has also been ordered to adopt measures to safeguard people's rights in terms of permissions to occupy land. For more, I'm joined by Lawson Naidoo from the Council for the Advancement of South African Constitution, also known as CASAC. Lawson, thank you so much for your time. For the benefit of our viewers, perhaps you could briefly give us a little bit more background as to how we got here to this particular ruling.
Well, it goes back to the demise of apartheid and the ending of the homeland system in South Africa, where all land that was previously in the custody of homelands, the Bantustans, reverted to the national state, with the exception of KwaZulu-Natal, where land that was controlled by the KwaZulu-Natal homeland was placed in the Ingonyama Trust, with the late King Zwelithini being the sole trustee. What this judgment today does is that it confirms that in terms of Zulu customary law, the residents of the land, today amounting to some 5.2 million people, are the true and beneficial owners of that land, and that the Ingonyama Trust is the mere custodian of that land and has to act in accordance with law as well as the constitutional provisions. And the court has ruled that the decision by the Ingonyama Trust to convert customary rights to land in the form of permissions to occupy and so on, to leasehold arrangements for a fixed term of 40 years was unlawful and unconstitutional, and has therefore set aside those leasehold arrangements and directed the Ingonyama Trust to repay monies that were paid in terms of rentals under those leases back to the residents of the land.
Right. In terms of their defense, I mean, do we know from your perspective what their defense was in, reasoning to, collect these leases and the monies over so many years?
Well, they tried to obviously put up some arguments saying that in terms of tradition that, communities were to be consulted, but they couldn't provide evidence that communities had been consulted. We argued that every individual whose rights were going to be impacted needed to be consulted and to give their free consent to such arrangements. The evidence that was before the court was that many of the people who signed these agreements were actually not even aware of what they were signing. The contracts were written in English, which many people did not understand, and they were really browbeaten into signing these contracts. And it is on that basis that the court ruled that this was unlawful, that proper consent had not been obtained from the residents on the land, and the court has taken a far-reaching decision to set this aside and really restore the dignity of people who reside on the land, that they're not subject to arbitrary removal from land that has been occupied for centuries and generations by families.
And I mentioned in my intro that the Minister of Rural Development and Land Reform has been ordered to adopt measures to safeguard people's rights. Does the court mention in what aspect she failed the people of this particular community and area?
Indeed. And this was part of our argument in the case, is that the Constitution in South Africa requires the minister to take steps to formalize informal and customary law rights that people have to land. This is clearly provided for in Section 25 of the Constitution, and we argued that the government, the minister, had not taken sufficient action to ensure that these rights were adequately protected and formalized. The court has now directed the minister to take urgent steps to rectify this and to ensure that people enjoy formal as well as protected rights to the land to which they occupy.
Lawson, thank you so much for your time. That is Lawson Naidoo from the Council for Advancement of the South African Constitution. As it stands, according to news reports, it is not yet clear whether the Ingonyama Trust Board will appeal the judgment. Of course, we will keep abreast of that particular news.